tell the truth about things that have happened. No more, no less. Don't exaggerate, don't minimise. Just tell the truth about what's happened. And then all you have to remember, and this is assuming that you've been telling the truth right the way through, so your statement is set out as truthful facts about what's happened and truthful facts about the evidence that you're giving, you've got nothing to worry about. Hello and welcome to this episode for the Survivor Diaries. This episode is about giving evidence at a contested hearing. It's something that I've seen a lot of questions about, and I've been asked a lot of questions about, and I do know quite a few people that are coming up to contested hearings that have asked questions about it, so I thought it'd be helpful just to set this out now. A couple of disclaimers, as I usually do. As always, I've got to specify that I'm giving very general advice. There's nothing that replaces being able to speak to somebody about your unique legal situation. And there are places that you can get free advice. We usually list those after the video, underneath the video on YouTube, so we'll put those there. As well as general advice, I am a solicitor in England and Wales. I work predominantly in private children law proceedings, but I also deal with other aspects of private family law, such as non-molestation orders. This episode is all about when you are told that you're giving evidence at a contested hearing. That could be in a range of different circumstances. So it could be the contested hearing for a child arrangements order. It could, in the final hearing, it could be a contested final hearing for a non-molestation order. Or it could be a contested fact-finding hearing. And I refer to other videos that we've done to see exactly where they fit in proceedings. These ones at the end, the final hearing, they're usually quite lengthy hearings, and the purpose of a contested hearing is for the court to hear evidence from both parties so that they can determine the facts of the case and what is the best thing to do going forwards. So therefore they're working out what orders to make. Now this makes a contested hearing rather important, as you can imagine, and a lot of people start to panic about how important this contested hearing is. Of course, it all feels like it's coming down to one day, one bit of time where you'll be allowed to speak, and everything seems to rest on this particular hearing. So lots of questions come up, and they range from, what will they ask? What if I don't know? What if I can't remember? I'm just reading off a list here of questions that I've seen. What if I go blank? What if they say I'm lying? Will they shout or be angry? What if I need the loo? Where do I stand? Do I stand? Can I sit? Can I see my ex? Can my ex see me? Do I swear on the Bible? How will I get across what's happening? And that's where there's a lot of pressure, this intensity of feeling that you have to get everything across in this one hearing. Everything rests on this. The whole life of your children, if it's child arrangements process, comes down to this one hearing. And it's understandably frightening. So the purpose of this episode is to try to remove that fear. And one of the ways that we're going to do that is by going through what will happen at a contested hearing and what it looks like to be asked or to be told that you're going to be giving evidence. What will that actually look like? And that can remove a lot of the fear. Going back then to one of the first of those questions, what will they ask? And then the last part, how can you get across what's happening? And I have seen people come to contested final hearings, even though they have representation, myself, a barrister, for example, they come to the hearing prepared to give a speech, prepared to try to explain to the court what's happening. They may have copious notes, they may have other evidence, they may have flashcards. I've even more than once had people turn up with flashcards of what they would like to present to the court. And you're not going to do any of that, basically. You don't need to do any of that. And I'll come to exactly why that is now. This is answering two questions, remember. It's what will they ask and how can I get across what's happening? Two really important aspects. Well, I can tell you what they're going to ask, or I can tell you whereabouts you can find it. And this is in your statement and evidence, and all kinds of contested hearings. And in this sense, although I'm in England and Wales, I would expect this to be before any hearing where contested issues are being looked at and evidence is being looked at. At some point there would have been a direction for the filing of a statement and evidence. And in filing your statement and evidence, refer to other videos that we've done for the filing of witness statements, you've set out everything that you need to tell the court about, and you've set out your evidence for why you think that way. That's one of the things you're going to be asked about. And it's just the evidence that you've already said. So that's very important. We'll come back to that in a minute. So you'll be asked about your own statement, and you'll be asked about the other party's statement, which you'll probably have seen because it was filed with the court and it should have also been sent to you. So there's 2 bits of information that you know. And my advice to my clients, to people I speak to on a pro bono basis, approaching the final hearing is to, if you're feeling nervous, reread your statement and evidence. A good witness statement has set out your evidence and your position and what you're asking the court to do, and therefore you just need to calmly reflect on your position as you approach the hearing. Do read the other person's statement, but don't focus on that too much. And yes, it is very common for the other person's statement to be very opposed from you. It may be even lying. You may know that those things are not true, and that may cause the panic as you go up to the hearing thinking, what if they believe all of the lies of this person? So there's some things that they're going to ask you. In fact, I can tell you the range of things that they're going to ask is to that statement, those statements, and also to any other things that have been submitted for the hearings. And all of this is contained in a court bundle. The court bundle, I'll just quickly go through that. It's usually the applicant's solicitor that will prepare a court bundle. If the applicant doesn't have a solicitor, it's the first respondent to have a solicitor, and they will be asked to prepare a bundle. So I might be representing somebody who's respondent, and because the other person, the applicant, is litigant in person, we do have to prepare the bundle. Alternatively, if both parties are litigant in person, the court wouldn't expect either of you to prepare the bundle, and the court's likely to prepare the bundle themselves. So what does a bundle look like? Well, it has a prescribed format, and if you want to see where the prescribed format is, you need to look at Practice Direction 27A, which is about the preparation of family court bundles. This would produce something which has an index looking like this, and Paul's going to flash this up on the full screen so that you can see it. It starts off at the top, it's got the case number. That will tell us whether it's non-molestation order, because it would say, for example, if it was Chelmsford, it would say CM, and then if it was family law proceedings, it would say F, and then the year 20. If it was children law proceedings, private children law proceedings, it would say CMP 20. So we can see what kind of proceedings there are from the case number. Again, this is something we've mentioned before. It has the applicant's name and the respondent's name at the top, and it says index to bundle for the hearing, and it will say what date the hearing is. And then it has a prescribed format from Practice Direction 27A. So it has the preliminary documents. Not something that you have to worry about too much. You can see in the practice direction what kind of things would be covered there. This would be any last minute position statements or position statements that were directed to be filed a little bit before this hearing, just clarifying the position. There might be a case summary in there. And if you've got a solicitor on the other side and they've written the case summary, they should have sent it to you to see if you agree with it. If you don't agree, don't panic, you just ask them to write applicant or respondent's chronology, and then you submit your own, and you call yourself obviously the applicant or the respondent, depending on what you are. Also in preliminary documents, you may have a chronology, I may have mentioned that, statement of issues, and a case summary. So they're the 3 types of documents that you might find alongside a position statement in the preliminary documents. Section B is always about the applications and the orders. So you may be asked questions giving evidence about something that you filled in the application form, or something that you filled in the response form. Particularly in applications for non-molestation order proceedings, there will be usually a statement attached to the application for a non-molestation order, for example, so that might be in there. They're things that you would be asked questions about. The orders, maybe not so much, unless there is something specific in the orders, such as an undertaking was made, or it's a prohibited steps order that you need to be referring to. And then, this is the critical bit, section C of the bundle, which is where the statements are. And this may be all statements that you may have produced. It would include your statements if you're coming to a fact-finding hearing, which is your statement of evidence, often set out with a schedule of allegations alongside it, and then the responses from the other person subject to the allegations. You've also got all of the other parties' statements in there, so you also know what you could be asked about that they've raised. So that's important stuff that you need to know. All the things you're going to be asked are in there, and in fact the court will not appreciate other evidence being introduced at this point in a contested hearing, unless it's something that's happened since the filing of these statements, in which case I can suggest that you maybe address that in a position statement. They're not going to accept things that haven't been put in the statement, so that hopefully will calm you down to knowing exactly what they're going to be asking about. Other things that could be in the bundle, in section D, you've got reports. So in child arrangements proceedings, this may be the reports of CAFCAS, either the Schedule 2 letter or a full section 7 report. It may be guardians' reports if there's a guardian appointed. And then other documents, you may be looking at police records, anything else that has been identified that's something that court wants to know and wants to have information about to be able to determine those orders. So police information there, maybe medical information, maybe expert reports if one has been asked for. So that's everything that you see that you're going to be asked about. And what's more, just to make it even easier, when you give evidence, that bundle should be in front of you. I will point out that I'm talking about the standard giving evidence that tends to happen in person, as it was pre-lockdown. However, it may be that you're having a remote hearing. You will need to have that bundle in front of you because a lot of people will refer to it. And this can help you with a lot of the other questions. What will they ask? Well, it's going to be in there. What if my mind goes blank? Well, they can direct you to a page number in the bundle and you can ask them to do that to where you've said it, and that may refresh your memory. The bundle's going to be in front of you. Other things to bear in mind that will help you to keep calm as you're approaching a contested final hearing. I've kind of briefly touched on this by saying that people like to, or they don't like to, but they get a feeling that they have to present a lot of information to the court straight away, and they've only got a small amount of time to do it, so they have to give this presentation and hope that everybody understands. It's nothing like that. You need to approach that completely differently. What you have to remember is you're being asked questions. So the thing that you need to do is to be able to listen to the question and think about the question. Any questions could be asked about the evidence or the bundle. Now, if it's something that you don't know, just say so. Giving evidence, the best advice is always just be truthful. If you don't understand the question, say, I'm sorry, I don't understand the question. If it helps, if you think that the person asking the questions is somewhat antagonistic with you, look at the judge. If you are live or if you're in a Skype, look towards the judge screen and ask, can you explain what that question meant? Now, it's fine to do that. And if you don't recall, if you don't remember, it's fine to say that. Tell the truth about things that have happened. No more, no less. Don't exaggerate, don't minimise. Just tell the truth about what's happened. And then all you have to remember, and this is assuming that you've been telling the truth right the way through, so your statement is set out as truthful facts about what's happened and truthful facts about the evidence that you're giving, you've got nothing to worry about. Because the only thing you have to remember is to look in your statement and to see what you've already said about it, and that is what you've said. And if it's the truth, it doesn't require any additional thinking, like, did you say that at that time? Is it going to conflict with another statement, etc.? So, okay, so there's just a few brief things. So if you haven't heard the question, it's okay to repeat, to ask them to repeat. If you don't understand the question, you can ask them to explain it. If you don't know, you just say so. If you don't remember, just say so. And telling the truth, as I've said, it means that the court gets to see that you are honest and reliable in your evidence. So that means telling the truth even if it's not helping your case so much. And it's helping you by telling the truth even if it's a bit ugly. Yes, I did lose my temper. Yes, I did say X, Y, and Z, and it wasn't appropriate. Okay, so telling the truth will mean that it helps the court better and quicker to get to the truth of the situation so that they can determine the orders to be made. And if you have a party who's not telling the truth in their statements, then as they're asked questions in this part, then this is when it becomes clear. And this is when the court sees that the evidence might not be reliable of the other party. So I'm hoping that this video will take away some of the stress approaching that contested final hearing. A few things that you can remember, so just summarising again. The contested hearing, the court's got to listen to both of you. It's very scary. We know what kind of things that they will ask. That's set out in the statements and it's also set out in the bundle. The bundle is going to be in front of you and you need to remember that you're being asked questions. So remembering that will keep you focused so that you don't have to feel like you have to give lots of information. You should have done that at the statement. Okay, I hope that's been useful. As I said, I just wanted to prepare that one just quickly because I have seen quite a few people asking questions and I've given quite a lot of the questions there before. I think I've answered most of them just looking down the list. Other questions, can they say you're lying? Well, technically they're asking questions, so I'd expect it to be phrased like, you're lying, aren't you? In which case, no, If you're telling the truth, no, you're not. Very easy. Will they shout or be angry? Even if they do, it doesn't stop you answering the question. If you remember, you're just there to keep it simple. Just answer the question. Don't go off into explaining or trying to persuade, just answer the questions. If you need the loo, you just ask for it. Do you stand or do you sit? Well, if you were live in a courtroom, you would go into the witness box, and that's following on to the next question. Do you swear on the Bible? You can either swear on the Bible or you can affirm to tell the truth. Can you see your ex, or can your ex see you? Normally you would expect yes. However, you can ask for special measures to be put in place. If you're actually in the physical courtroom, you can have screens put up between you, and so those screens would also cover you in the witness box as well. Okay, I think we've covered everything else, and so I hope that's useful, and I look forward to seeing you in the next episode and or vlog. Thank you very much for watching, and bye.